On May 19, 2025, prosecutors filed a criminal complaint for assault or assault and battery against 33-year-old Alexis Brown in the 14A District Court in Washtenaw County, Michigan. Ms. Brown was ordered to appear for an arraignment and pre-trial hearing scheduled for June 18, 2025. Ms. Brown did not appear in court, and a so-called show cause hearing was scheduled for July 2, 2025. However, Ms. Brown also did not appear for the show cause hearing, and a warrant was issued for her arrest. Ms. Brown was taken into custody, and on July 14, 2025, she appeared in court for her arraignment. Because she had not made bond, Ms. Brown remained in custody after probable cause was found at the arraignment. On July 17, 2025, the Washtenaw County Office of Public Defender entered an appearance to represent Ms. Brown as her defense counsel. On the date of the hearing, Assistant Public Defender Lauren Perrine was available to represent Ms. Brown, but she declined her assistance, choosing to represent herself instead.
Court calls the case of the People versus Alexis Brown.
Good morning, Assistant Public Defender Lauren Perrine on behalf, well, not on behalf of Ms. Brown. We are the attorney of record on this case. When I did meet with Ms. Brown, she informed me she wants to represent herself.
Your name?
Alexis Brown.
All right. Is that correct that you want to represent yourself?
Yes, it is.
So, in this matter, Ms. Brown, I do have to inform you that the complaint in this case alleges that on or about June 8, 2024, the location of 3001 Woodland Hills Drive in Pittsfield, Washtenaw County, State of Michigan, that you did commit the offense of assault and or assault and battery against a Latasha Browning. Do you understand what you're charged with?
Yes, I do.
That is a misdemeanor, punishable by 93 days in jail, $500 fine plus court costs. Do you understand the maximum penalties?
Yes, I do.
There are certain things that are fraught in self-representation in terms of understanding the Michigan court rules and in terms of the court procedure. You would need to understand that if you would like to represent yourself, that you would be held to the same standard as any other attorney.
Mm-hmm.
The court will not be assisting you in any fashion whatsoever. You understand that?
Okay, so the time that I served, don't that counts for the 93 days?
I'm sorry?
The time that I served already, don't that counts for the 93 days?
I don't know how much time you served.
I served 30 days already.
And if you serve 30 days, it may count. I'm trying to look at what your bond is on this case. What do you have a bond?
And then no contact with the victim's loan.
And the monetary amount?
5,000,
10%, then it should count. Yes, ma'am.
And so I have a question. So when I was arrested, I wasn't actually told my rights. So ain't that against the law that you wasn't told your rights when you arrested me? Well, not you, but the officer.
I cannot.
You can't do nothing about it right now?
I
All right, I just want to state that.
I can't answer that.
I just want to state it.
All right.
Okay.
Stated.
It's on record, right?
Ms. Brown asks if her arrest was illegal because she was not read her rights, and Judge Simpson informs her that he cannot answer that question for her. Contrary to common belief, an arrest is not unlawful simply because officers do not recite the so-called Miranda rights at the time of the arrest. In the 1966 case of Miranda versus Arizona, the Supreme Court established a narrower rule. Before conducting a so-called custodial interrogation, meaning questioning while the suspect is in police custody, officers must inform the suspect of the right to remain silent and the right to counsel. If officers fail to give these warnings, the arrest itself remains valid. However, any statements the defendant makes during a so-called unmirandized custodial interrogation may be suppressed, meaning that the statements cannot be admitted as evidence in later court proceedings. Now, despite the fact that Ms. Brown appeared to be mistaken in her understanding of the law, Judge Simpson was unable to answer her question, as it would exceed his role as a judge and provide an unfair advantage to Ms. Brown. Canon 3 of the Michigan Code of Judicial Conduct requires judges to perform their duties impartially and to avoid conduct that could create an appearance of bias. The canon also acknowledges that judges may make quote-unquote reasonable all efforts to help self-represented litigants understand the proceedings and have a fair opportunity to be heard. At the same time, the canon cautions that these efforts must not give self-represented litigants an unfair advantage or compromise the judge's neutrality. Because of this limitation, judges may explain procedure, but they cannot provide substantive legal advice. In Ms. Brown's case, had Judge Simpson answered her Miranda rights question, he would have crossed that line into advising her on the law, which is a role that's reserved for attorneys, not judges. Accordingly, providing such advice could reasonably be viewed as inconsistent with the impartiality required under the Code of Judicial Conduct.
So,
Okay.
what do you want this set for, ma'am?
I mean, Your Honor, we have no offer at this time.
Do you want it set for a trial, ma'am?
Sure, I guess. I guess
You want a jury trial or a non-jury trial?
it doesn't really matter.
Well, you got to make a decision, ma'am.
If it gotta go to trial, then it gotta go to trial.
Okay. Do you want a jury trial or a non-jury trial?
It doesn't matter.
You have to make a decision, ma'am.
It could have a jury. Fine. That's fine with me.
Judge Simpson requires Ms. Brown to decide whether she wants a jury or non-jury trial, and a final settlement conference and jury trial are scheduled. In the 1968 case of Duncan versus Louisiana, the Supreme Court ruled that the Sixth Amendment guarantees the right to a jury trial to criminal defendants in so-called serious criminal cases. 2 years later, in the 1970 case of Baldwin versus New York, the court clarified that a so-called serious crime is one where the possible sentence exceeds 6 months in jail. Therefore, for 93-day misdemeanors, like the charge against Ms. Brown, the federal constitution would not require a jury trial. But on the other hand, Article 1, Section 20 of the Michigan Constitution states that in every criminal prosecution, including offenses punishable by less than 6 months imprisonment, the accused has the right to a jury trial. This is a broader guarantee than the federal standard and would apply to the charge against Ms. Brown. However, even though the right to a jury trial is protected, under Section 763.3 of the Michigan compiled laws, a criminal defendant has the option to voluntarily waive their right to a jury trial and opt for a bench trial, where a judge decides the case. Here, only Ms. Brown could waive her right to a jury trial, which explains why Judge Simpson could not decide for her, and why Ms. Brown ultimately chose here to exercise her right to a jury trial.
Jury final settlement conference in this matter will be set for 17th, 2025. At 9 a.m. Jury selection in this matter, October 20th, 2025. At 8:30, both of those proceedings are in person. Thank you.
So am I free to go? So why am I not free to go? If she just said she got a bond,
Pardon?
why am I not free to go? Why do I gotta serve time when I'm not even?
You have a bond on the case, ma'am.
So if I get my money, I can get out.
If you
But she just said it was no bond.
post bond, you can get out.
So I'd rather post bond. So where do I go from here?
You need to post the bond.
Okay, what's the bond? Cause you just asked her the same thing. Cause she said
5%.
it's $500.
Yes, ma'am.
Okay, so I'd rather post bond. Where do I go from there?
And you can go post bond.
Okay, thank you.
It's your fault, parenting. Your fault. You just like suckered me into that. You got up there and then just said, well, we're the attorney of record, but
Oh, we're starting off the morning with a series of bad decisions already. This is wonderful.
yeah, I know, but they're all by Kearney. The whole McDonald's thing and then this. And...
This-
Okay, let's try this one.
As of the date of writing this episode, Ms. Brown's case remains open, with the settlement conference scheduled for October 17th, 2025, and jury selection scheduled to begin on October 20th. Court records also show that she has yet to post bond. The second proceeding in today's episode was held in the courtroom of Judge Kristen D. Simmons in the 54A District Court in Lansing, Michigan. On February 20th, 2025, Judge Simmons entered a judgment evicting tenants Chase Carson and Amanda Wilson and ordering them to pay their former landlord $9,890.08. Mr. Carson and Ms. Wilson did not pay the judgment, and the landlord's attorney, Jessica Larson, attempted to garnish their wages and bank accounts. However, these efforts largely failed, as the landlord did not have their current bank and employment information. And on August 19th, 2025, a so-called debtor's exam, which is a court-ordered proceeding allowing a judgment creditor to question the debtor about their finances under oath, was scheduled for a virtual hearing.
Mr. Carson, you can remove your hat. This is the court proceeding. Today was the date scheduled for a discovery or a debtor's examination. Were you able to complete your exam?
No, Your Honor. Mr. Carson refused to answer any of my questions. He said he's not going to play games with me.
What games are being played, Mr. Carson?
Well, Your Honor, when I was previously there, I received a verdict by you that I believe to be emotionally charged due to your frustration with my inability to complete the tasks of a lawyer. I attempted to get a lawyer through the system. They denied me. I had to show up last minute unprepared, and things didn't go my way. So I figured, I'll do the process. I'll try to appeal it. I go downstairs and I'm told I have to pay $200 and some to even have a chance to get a fair trial or verdict. I'm having one individual who was emotionally charged at the time decide what has to happen to me instead of a jury of my peers. And now I'm being told I have to produce all my financial statements, documents, vehicles, titles, all this. And I have no interest, time, or energy to continue this charade. I've lost several days of labor.
Let me stop you because I'm just getting updated on this case. This was a landlord-tenant hearing that I presided over. Did you demand a jury trial?
I'm sorry?
Did you make a demand for jury trial in landlord-tenant?
I requested, yes.
You was there a demand on
in written? I didn't put anything in writing. I did request the trial. I went downstairs and asked what my rights are, and they said to proceed any further past your decision, I had to pay $200 and some to even try. I did not have the money at the time, nor would I have it.
Sir, I asked you to let me get caught up. I'm trying to see if you have filed a jury demand. Let me also be clear. I don't make decisions because I'm emotionally charged.
No,
don't talk over me. Don't talk over me. Just because I won't let you run my courtroom does not mean that I am emotionally charged. There's order that will be set in the courtroom, and you will not talk over people. You will present the evidence. I'm absolutely fair and impartial, and you then have the right to appeal my decision. Just because you disagree with the decision doesn't make it impartial, okay? And if you don't follow, there's rules in place that I don't set as to how you file such appeal. If the clerk's office told you what you needed to file to move forward with the appeal, then that's what you needed to do. But I'm going to make it clear on my record that I don't make, and I did not make a decision in this case based on any emotions. I have no reason to be emotional about your eviction, sir. I'm not being evicted. So if you keep talking over me, this is probably what you did the last time. It's try to cut me off. Yeah, and you're shaking your head. So that's not me being emotionally charged. That's me not allowing you to run my courtroom. You don't talk over people. You have a question.
Yes, I was just speaking and you cut me off, but I'll let I run
the courtroom.
Okay, I understand.
Did you notice that?
May I finish, Your Honor, please?
Yes.
Okay. At the time of the last proceeding, I interrupted you. I apologize. But the second or third interruption, you stopped me in the middle of my sentence and awarded them the decision. You know what? You were like, you know what? Decision for them. You didn't specify why. It was just an emotionally charged because you were frustrated with my inability to complete the tasks of a paid lawyer.
I have I have evictions every single week, and the majority of my evictions are people who do not have attorneys. I don't know if you know that. Over 75% of our cases do not have attorneys representing them. I do not get frustrated with your inability to do the task of a lawyer. Where I will get frustrated and where I will not tolerate is if you think you're going to yell out or yell at the other party, yell at me, and you're going to act a fool in the courtroom, I will no longer allow you to be heard. Just because I cut you off and make a ruling does not mean that I ruled in their favor because I was frustrated with you. I was going to rule in their favor anyways because of the facts of the case. I was allowing you an opportunity to be heard. But when your opportunity to be heard becomes a hindrance to the procedure in the courtroom, then I have to terminate the hearing. And so if you want to proceed in any other manner, I don't know what your rights are now at this point as it relates to your right to appeal. You may have exhausted that time frame, but you're going to need to appear in person. I'm going to reset this since you refuse to comply with the court order to participate with the discovery proceeding. Because this is an official proceeding. This is not your option. You have to participate in the proceeding because you have a judgment against you and the plaintiff has the right to figure out how they can recover on that judgment.
Can we
Do
speak?
you understand that? Yes, you may.
Well, we tried to tell her, like, the funds, we can pay them. Like, we have no problem with that. We tried to tell her the same thing.
What is the past due amount?
It's roughly somewhere in the ballpark of $10,000 with interest, Your Honor.
And
I asked him if they could make a payment in full, and he wanted to argue the merits of the judgment itself. I never heard an indication there would be a payment in full. If there's some sort of payment plan, I'm happy to discuss that once I get my questions answered, because they have made no efforts to make payment on this, never reached out. We've tried multiple different avenues for the information that we did have on where we thought they banked and where we thought they worked. So I would need answers to all of the debtors exam questions, and then I'm happy to work out a payment plan. In the event of a default, then I can pursue other arrangements.
Okay. Are you in a position to pay in full the past due amount?
I'd prefer a payment plan. I would like to see what the interest is and what the original charges are. I was never actually formally presented with any numbers, despite what she had just told you. Until we were physically served for this court date, I had heard nothing other than a couple of emails where they were denied requests to garnish.
Yeah, we haven't received.
That is literally the only thing pertaining to the case I have seen since I walked out of your courtroom, attempted to file for an appeal and was told I had to physically come up with money to do so that I didn't have at the time. So I at no point was ever given a fair trial. I was given an opportunity to pay for one potentially. But I've received, like, the judgment is for, you gave them and rewarded them things they shouldn't have had. We weren't there.
If you disagree with the court's position, you have the right to appeal. You failed to do that. I also want to correct the record again. You did not properly file any demand for jury trial, although being advised on your first appearance of how you have the right to a trial and how to file such jury trial demand. You did not file a jury trial demand. So if you didn't get a trial, that was on you.
Judge Simmons informs Mr. Carson that if he wanted to argue the merits of the judgment, he should have filed an appeal. She also explains that if he wanted a jury trial, he needed to file a jury demand with the court. According to Rule 4.201 of the Michigan Court Rules, when a judge issues a judgment against a tenant in an eviction case, the tenant must file an appeal or a post-judgment motion within 10 days. To file an appeal, there is typically a so-called filing fee that must be paid to the court to compensate for the administrative services involved in the case, such as processing paperwork, managing the case docket, and scheduling hearings. So this is likely the quote-unquote $200-some that Mr. Carson referred to earlier in the hearing. Because Mr. Carson and Ms. Wilson did not file an appeal or post-judgment motion by this deadline, they lost their opportunity to challenge the decision, and it became final. Likewise, Rule 4.201 also states that if the defendant in an eviction case wants a jury trial, they must demand it orally at their first appearance in court or in writing within 5 days of being advised of their right to a jury trial. Accordingly, because a proper jury demand was not made, Mr. Carson and Ms. Wilson forfeited their right to a jury trial.
Then I guess I misunderstood, and that goes back to me not being a lawyer and wishing that I had.
That does not go back to you being a lawyer. We made a video. We make a virtual presentation. It's a video that I play, and every courtroom in this court plays that video at the first appearance. Most of you all don't pay attention to the video. It tells you very clearly in very plain language. You have the right to a jury trial. And you can make such demand for a jury trial, and it tells you how to do that. You don't need to be an attorney to do that.
Sorry, go ahead.
I'm done.
Can she produce an actual number, or are we going off of what she thinks?
So I'm asking for what's in the judgment plus whatever interest is, and I haven't calculated it.
You wouldn't have calculated that before today?
You can do one of two things, sir, because I'm not the games that are being played, I do not believe are on the part of the plaintiff at this point. You can participate in good faith right now in the debtor's examination, provide the answers to the questions, which are under subpoena. You've been ordered to court for this purpose. Or I can reset this and order you to appear in person. If you fail to do that and to comply, then we have to proceed to a next step, which is a bench warrant. And I don't think you want a bench warrant over a civil matter. So it's in your best interest to comply. It sounds like she's willing to work with an installment payment order, but only after she gets the answers that she needs to figure out how they're going to recover on this debt. So how do you want to proceed?
I'm sorry, Your Honor.
I'm sorry.
I asked him if he had any of the documents there were, in addition to information, those documents, plenty of documents that were asked for, and he indicated that he wasn't going to produce those. So I would ask him to appear in person with all of the documents.
Oh.
And I'd also ask that, Your Honor, that he return to a tone that is respectful. He has screamed expletives at me the last time we were here in court, and he's called me things today. And it's uncalled for and unnecessary.
I am absolutely clear that the emotional charging was not from the courtroom. I'm not going to allow you to berate anyone in this courtroom, nor will you disrespect me or the process. You can appear in person. I'm going to reset this date, and you need to bring the documents that were ordered under the subpoena. If you fail to comply, the court will issue a bench warrant.
Your Honor, save yourself the time. Have her facts.
Don't tell me what to do. Don't tell me what to say. You instruct yourself.
I'll pay her
You instruct yourself. You instruct yourself, or you'll be in contempt of court. Okay?
Excuse me?
You control your own mouth. Don't tell me what to say. I've already given you an opportunity. I'm now resetting this. You can appear in person. If you pay in full, then they can move forward to make sure that this removes off of my docket. But do not tell me what to do. I do not tolerate your tone. This is how we got here the last time. That might work with the lady sitting next to you, but you don't talk to me like that. Not in the court, not outside the court. Do you understand that?
I'll pay the balance.
Thank you.
My phone number is on all of the court paperwork. You can give me a call and I'll give you a number.
Give me a new date.
September 4th at 1:30.
September 4th at 1:30, you said? Yes, in person at the court. If you pay in full, you can provide evidence of that and have this removed from my docket. Any additional matters for the record?
No, Your Honor, thank you very much.
Save the tax and money.
Mute him and remove him from my courtroom before he's in contempt.
Judge Simmons rescheduled the hearing for September 4th, 2025, ordering Mr. Carson and Ms. Wilson to appear in person with the financial documents that Ms. Larson requested. Court records show that on the date of the scheduled proceeding, Ms. Larson filed a certificate of satisfied judgment, indicating that the judgment had been paid. Overall, these proceedings illustrate the risks of self-representation. In Ms. Brown's case, not only did she struggle to identify the hearing's purpose and what was required of her, she also appeared to believe that her arrest was unlawful unlawful because no one read her Miranda rights, when, in fact, Miranda rules limit the use of statements from custodial interrogation and do not, by themselves, invalidate an arrest. Judge Simpson could not answer Ms. Brown's legal questions or steer her strategy, because judges may explain procedure, but they cannot provide substantive legal advice without compromising their impartiality. A defense attorney, on the other hand, could have clarified how Miranda works, determined whether any questioning was quote-unquote custodial, and, if appropriate, filed a motion to suppress any affected statements. Now, in Mr. Carson and Ms. Wilson's case, Mr. Carson in particular demonstrated a lack of knowledge regarding courtroom processes and the appropriate avenue for challenging the judgment against him. An attorney could have helped him maintain proper etiquette in the courtroom, understand the purpose of each proceeding, and meet the appeal deadline to challenge the judgment against him. The broader takeaway from this is that courtroom rules and remedies are technical, and proceeding without counsel heightens the risk of misunderstood rights, missed deadlines, and asking judges questions they are not permitted to answer. Let us know if there's a case or courtroom interaction that you'd like us to cover in the comments below. Thank you for watching, and don't forget to subscribe and share so that we can help foster a more informed society.